two types of events that either occur on the private property or public property. So public property is government property, and private property is something privately owned, like an apartment parking lot, for example, or a shopping mall parking lot. Now, you can be involved in a slip and fall or a trip and fall. Slip and fall quite typically arises due to winter maintenance issues, such as the accumulation of ice or snow. Sometimes it's not. Sometimes it could be an oil slick or something else. So that's a slip. Very, very simply, it's a slip and fall. I don't have to explain that. A trip and fall is related, and a trip and fall would be a type of accident where there's a physical defect with the surface, the walking surface, be it a sidewalk, be it a parking lot, be it a roadway, whatever it is. It could be a discrepancy in terms of a ledge that you were unable to negotiate that caused an accident, caused you to fall or injure yourself. It could be broken pavement. It could be many, many things. In any event, if the trip and fall or the slip and fall occurred on private property, so it's usually governed, or almost always governed, by the Occupiers Liability Act. So the Occupiers Liability Act is an Ontario statute which requires either landowners or persons who have control of the property, such as a property manager, to take positive measures in the circumstances to ensure that the property is reasonably safe for people who enter onto their property. And how do you do that? Well, according to the law, that entails a positive duty to inspect your property and have some form of maintenance. The law doesn't say exactly what you have to do in order to discharge that duty, but they tell you, the law states that that has to be done. Inspection, maintenance. Why? To ensure that it's safe. On public property, typically the accident would occur on a sidewalk. Now, if there was an accident on a sidewalk, either a slip and fall or a trip and fall or some other issue that caused injuries on a sidewalk, the law requires that the party provide notice within 10 days of the incident. So the reason is that so the city is notified and they could investigate the condition that was alleged to cause the accident. And that would allow the city to remedy the situation. And there's also a principle called prejudice. So prejudice would arise potentially if the city did not receive notice within 10 days and you decided to sue a year or 2 years later, and the city would likely take the position that they don't know about the condition because they have quite a bit of sidewalk and they weren't able to photograph, investigate, send an adjuster to the accident location in order to determine what the cause was. So they're going to say we prejudiced in our ability to defend the case. So those are the two types of cases. In both of those cases, the forum or the way to bring the place where to bring that, technically that's what forum means, to adjudicate your action would be by way of a legal action in Superior Court of Justice. You would commence your claim, make a demand for damages, and it would go through the litigation process. So I think I've described the litigation process and major steps in the litigation process. Some of them my tapes. That's everything in a nutshell that I have to say. Thank you.